mediation, which we think of as informal facilitation of negotiations, normally has several ends or aims. One is to resolve a dispute or disputes between parties. However, it can accomplish a variety of other goals at the same time. For example, we talk about the importance of business and personal interests, elements of disputes that normally don't even get talked about when you're in court because they're considered irrelevant. They're not germane to the way a court, a judge, or a jury would resolve a dispute. They just don't matter. On the other hand, they matter very much to the parties. They matter to the people who are in conflict. And we know that mediation can, among other things, help to focus in on what really matters to the parties. Not necessarily you're right or you're wrong and I'm right, but we both have interests here that demand or at least make a persuasive case for getting things resolved informally. Mediators act in different ways here in the United States. For one thing, they may play what they describe as a very facilitative role. And most people would probably say, well, I facilitate a resolution of conflict. And facilitate is a very fuzzy word. But for a lot of people, that's a code word for I don't express opinions. I simply work as the agent of communication and change between or among the parties. It's their dispute, it's their problem, and I'm simply trying to lay the groundwork for its resolution. But I'm not a judge, I'm not an arbitrator. I'm someone who is simply there to try to resolve it on terms that are mutually acceptable to them. On the other hand, we do have a lot of mediators, including many experienced mediators, who say, well, there come times when it is important to inject an element of evaluation into a process. And sometimes I'm asked to comment on likely results if this case goes to court. I may be asked to propose terms of a settlement, which may or may not involve evaluation, but it certainly seems to put the mediator on the line, if you will. Other mediators say, you know, I tailor my approach to the circumstances. Sometimes I'm very laid back and I'm extremely careful about saying anything that would betray something that might be considered as an expression of opinion or reflecting positively or negatively on what someone has told me. But as time goes on, I become increasingly directive or increasingly pointed with my questions. So I guess the important thing to keep in mind is mediators act in many different ways and see their role in different ways. And in fact, some mediators will tailor their style and their strategies very closely to the circumstances that they're confronted with. Now, why am I telling you all of this? Well, to simply lay the groundwork for an explanation of the differences between our system as it's evolved and evolved in fairly modern times from a very old, very venerable system that exists in China. When our Chinese colleagues spoke about mediation or conciliation, that's the term they often use, they're really talking about something that is in their bones because it has existed for countless generations in China. And it has been a part of the evolution of communities in China. But it comes from a different place. They were mediating at the time of Confucius and before. And Confucian philosophy talks about the importance of peace and harmony in the community. Those are pervasive values in Chinese society. They always have been, regardless of the form of government that they have had. There is this notion traditionally of an individual as really being part of the larger community, of the larger organism. and having a responsibility as a member of the community to maintain harmony, to respect the peace and the order of the society. Now contrast that with the United States. We are rather ornery in our independence and in our individuality, almost to a fault. And our legal system and our ways of resolving disputes reflect that. What I described to you in terms of a modern mediation system was really a reflection of modern American attitudes toward autonomy, individuality, and individual rights and interests and their vindication, as well as our independence in making decisions for ourselves. When we talk about mediation in China, historically and even today in the present, we're talking about something different. There's a wonderful movie that was produced in the early 1990s by a famous Chinese director, and Zhang Li, the famous Chinese actress, is the central character. It's called The Story of Chao Zhu. And it's the story of a woman whose husband has an altercation with the local village chief. The chief injures him. Now, her husband is perfectly happy to let bygones be bygones. After all, they're related to the chief. In fact, I'm sure most of the people in the community are relatives of some kind. So there's this network of relationships. Also, he is the chief. And so the husband was saying, let's just let things lie. But Chao Zhu said, no, we can't do that. I want justice. Now, she didn't clarify what she meant by that. But she went above the village chief's head, and she went to a local official who wears a uniform and has an office where people come and make reports. And the local official came to their village, and he talked to Chao Zhu and her husband, and he talked to the village chief. And then he did something interesting. He described the process as a mediation. But when all was said and done, it was this official who proposed a solution. He said, this is what I think we should do. I want the village chief to pay money to Chao Zhu's husband and to make an apology. Now, this was basically something that he brought forth by himself. And it was clear that in doing so, he was speaking in an official capacity, but more importantly, as an agent of the community. He's saying, the community needs you to resolve this dispute. It's not good for the community for you to have these issues outstanding. It's not consistent with peace and harmony. And so he not only said, I think you should do this, but I think in accepting this, you should engage in self-criticism. You should both look inside yourselves and see if there isn't a way that you can't accept this. So notice, rather than someone who's facilitating a resolution between two independent actors, what's he doing? He is a figure of authority, a venerable figure, but a figure who is cloaked with authority, who's basically saying, well, in this mediation, yes, there's an accommodation between individuals, but what we're really talking about is looking at this within the framework of a society. In fact, even today, community mediation is a very, very important part of Chinese society, and there are mediators, literally tens of thousands, if not millions of mediators, operating all over China. And these traditional community and neighborhood mediators exist even in the heart of Beijing. 2 years ago, our Asian Study Tour class had the wonderful opportunity to actually go and meet some of the mediators at one of the leading mediation centers in the center of Beijing. And of course, the kinds of things that they resolved were neighborhood disputes, the use of water within an apartment building, someone disrespecting someone else, those kinds of things. And they worked extremely efficiently. They did not sit around a conference table with people. They had an office, and people would come in and talk to them, and they might type notes on the computer. They might go out and visit people. But it's not the kind of give and take negotiation styles that we see in the United States. There may be negotiation going on, but again, it's coming from a very different place, and it's serving somewhat different ends. Yes, there's individual dispute resolution, there's individual accommodation, but again, it's done under different premises. Even though there's not formal mediation, there's no question there have always been opportunities for negotiation, including negotiation with the help of someone who is a friend or an acquaintance, somebody in a position of authority, who's not there because they're appointed to do it. They're simply they're helping a friend, or they're helping someone who they think needs help. For example, if you look at the typical commercial contract, there is language to the effect that says the first thing we're going to do if we have a dispute is to engage in a period of friendly consultation. That's the way they put it, friendly consultation. Now, that doesn't mean mediation, but it does mean, all right, we'll talk. And that may or may not be a real period of discussion or interaction. It may be nothing more than a postponement of the resolution, as it sometimes is in the U.S. But sometimes it is an opportunity for someone to go to a friend that might have some leverage, might be maybe you talk to a local government leader. Not like the story of Chao Zhu, where you're going to a person who has an official capacity to resolve things, almost like an administrative decision. It's not like that. What I'm talking about is informally. You say, we've got a problem here. Can you help us get it resolved? And that actually may be the germ of something that is the closest to what we think of in terms of someone mediating, even though they're not being paid to do it. They're not a formal mediator per se. And in fact, they may be aligned with one of the parties, but nevertheless, they're in a position to help. And so you do have that possibility. We'll talk about that during the Asian Study Tour, and there'll be people who can give you examples of that. There's also mediation in China in the courts. And I want to contrast this with what happens in the United States. In the U.S., we typically say that judges judge and mediators mediate, but they're two different things. If you're engaged in conversations with people about the intricacies and sensitive issues surrounding a dispute, that's one thing. We want you to be able to talk to them and for them to talk to you very candidly. They need to be able to talk to you and say to you things that they wouldn't tell someone who is judging them, someone who holds their destiny in his or her hand. So we typically say that it's inappropriate for a judge, whether it's a public judge or a private judge like an arbitrator, to also mediate. And that's a pretty firmly held conviction by a lot of people. It's written into various rules, in some cases laws. Is it always abided by? No, it's not. But if you got a group of American lawyers here in the room and ask them to vote on whether or not a judge of a case should also mediate, I can guarantee you that 95% of them or more would speak very sternly about the fact that the two concepts are incompatible. Judging and mediating are two different things with different ends. And no good can come of having a judge act as a mediator or a mediator turn into a judge. In China, the expectations are different. And in fact, there is a tradition of Chinese civil court judges acting as mediators, that is, trying in some way to get disputes resolved, maybe suggesting a resolution, just like the mediator I told you about. And then if they can't get it resolved, they judge it. Likewise, in private arbitration proceedings, private adjudication, there is a tradition and there are rules that say arbitrators may act as mediators. They can try to help the parties get the dispute resolved informally. If that doesn't work, then they turn into judges and they judge the dispute. Now, is that right or wrong? Well, it's neither. It's different. And in fact, China is not the only culture that embraces these mixed roles. Clearly, arbitration has been the real key alternative to the courts that people have looked to and still look to and will continue to look to, I think. In the international arena, arbitration is just essential. Why? Because someone is always going to be in the other fellow's court. If you're an American doing business in Beijing, you would prefer not to be in the court system because it's not your court system, and there are worries. It's the same here in the United States. If you're a Californian and you go to Missouri, you may say, gosh, I don't want to be in a Missouri court if the other party is a local business or a local figure of some kind. So those are always concerns in the international arena where you have cross-border transaction, always. Someone is always saying, gosh, I'm worried that my ox is going to be gored. So we've got to have some relatively flat, relatively even playing field, level playing field that we can operate on. Then the question becomes, where do we arbitrate? And there has been a tradition on the part of parties outside China saying, well, let's arbitrate outside China. Let's go to the American Arbitration Association, or let's go to the ICC in Paris, International Chamber of Commerce, or let's go to Stockholm. And in fact, you may say, why Stockholm? Well, interestingly, if you look back, say, 10, 20 years, Stockholm was where all of the disputes, it's traditionally been the place where disputes between American businesses and Russian businesses were resolved. And of course, the Chinese saw that the Russians were getting things resolved in Stockholm during the communist era, so they said, well, we'll do the same thing. We'll agree to Stockholm. So they go all the way to Stockholm to get a dispute resolved between an American party and a Chinese party. There are more recently more developed regional centers, Singapore and notably the Hong Kong International Arbitration Center. And by the way, we'll be visiting the Hong Kong Center on our tour. Interestingly, arbitration in Hong Kong is a little different from arbitration in Beijing. It looks more like what U.S. people are used to. So what I would say to you is, if you were an American contractor, for example, or an American company, you'd probably say, well, I'd like to arbitrate in Hong Kong. And because I know that the rules there and the practice there is a lot like it would be in the U.S. or in England or on the continent of Europe. But it's actually closer to England or the U.S. because you have the common law heritage in Hong Kong because of the British influence. So, in fact, another thing we'll do is visit the courts in Hong Kong. You'll see these Asian lawyers wearing wigs, just like their British counterparts, British barristers. And even though arbitration is a totally private proceeding, it can't turn its back on the influence of the public courts. It is a reflection of the larger system. And that's true of arbitration in China as well. Chinese courts, which we'll also see in Chinese arbitration, are much more condensed proceedings. I saw a whole civil case played out in an hour, and it was a very high-profile case. A woman was upset because someone had used her image against her will. She was a beauty pageant queen, and a hospital put an advertisement on the air showing that she'd had reconstructive surgery, and they had before and after pictures. Well, she lost her title, her beauty title. So, not knowing what else to do, she sued the hospital. Well, the contract was pretty clear. She'd signed away her rights, apparently. And so chances are she would have been booted out of court in the U.S. as well. But interestingly, because of the vagaries of Chinese procedure and the differences and the focus on a much more summary proceeding. There's much less testimony, much more emphasis on documents. The whole thing was over and done with in an hour. We saw the whole proceeding from start to finish. And what's more, the judge came in and made a judgment within about 20 minutes. So it was all over, and we saw the whole thing. There have been these alternatives that businesses have always looked to. Today, there are a growing number of choices, and the important thing to keep in mind about the Beijing Arbitration Commission is that I think it is probably trying as hard as any mainland China institution to project itself as an arbitration body that is similar to other international bodies. Now again, they all vary somewhat because of the legal system in which they're founded.